Ever walk into a room and instantly feel the weight of every eye sizing you up, waiting for you to stumble? That was me on Tuesday morning, standing in a packed courthouse with the air so thick with tension, you could cut it with a knife. And there she was, Karen Whitfield, sitting across the aisle like the queen of some low-budget drama series, dressed to impress in a designer suit, lips pursed and whispering to her flashy young attorney like she already had the victory speech drafted. The look on her face said it all. Watch this cowboy get crushed by the mighty HOA. And for a split second, I almost chuckled. But there's a part of me that's seen its share of corporate battles and back-alley brawls, and that part knew I wasn't going to let her win, at least not without one hell of a fight. Then Judge Morrison called things to order, and the room went quiet. He asked if I had legal representation, and I stood up slow and steady, adjusting my tie. I'll be representing myself, Your Honor. You should have seen the expression on Karen's lawyer's face. Bradley Cooper, young and cocky, with that polished law school swagger. He smirked. Poor kid had no idea he was about to get steamrolled by someone who's been chewing up courtroom bravado since before he could shave. When the judge asked for my background, I laid it out plain. Thomas Mitchell, retired attorney, specialized in property law, 35 years in the trenches, licensed since 1987. The smirk vanished fast. And Karen? She looked like someone just unplugged her entire plan. Now, to understand how it got to this point, I need to rewind a bit. See, Cedar Ridge Ranch was supposed to be my retirement, my peace and quiet after a long career. I bought those 100 acres for solitude. Just me, my horses, and the grandkids on summer breaks. No HOA. No neighbors poking their noses into things that weren't their business. The man I bought it from, Jim Henderson, made it crystal clear this property had never been and would never be part of any homeowners association. 2 miles down, behind a strip of county land and a wall of old pine trees, sat Willowbrook Estates. That whole circus could stay right where it was, far from my fence line. And for a year it did. Sunsets were peaceful, nights were still. Then along came Karen. It was October. I remember because the air had that crisp, wake-you-up chill to it. I was fixing a section of fence when a spotless white Lexus pulled up. Out stepped Karen Whitfield, every hair in place, clipboard ready, already eyeing me like I didn't belong on my own land. "Excuse me," she called out. "I'm Karen Whitfield, president of Willowbrook Estates HOA. We need to discuss trail access for the community." She spoke like she was offering me a favor. I walked up, made sure to keep the gate between us, and said, "Ma'am, this land isn't part of your HOA." Her smile tightened just a bit. "Well, that's what we need to discuss. A trail would benefit everyone." To her, I was being unreasonable. To me, she was out of line. I told her straight, this property's never been under Willowbrook's jurisdiction, and it never would be. That's when I saw it. That look in her eyes that said she wasn't going away. This wasn't a polite inquiry. It was the start of a mission. From there, things got strange. Letters started coming in, each one more official than the last, summoning me to HOA meetings like I was one of her subordinates. Then came the bogus complaints, noise violations, zoning nonsense, anything to get an inspector to my door. Most of them just apologized for wasting my time. Karen began leading group walks, bringing nosy neighbors to my fence line like I was some rare species in a zoo. They'd point, take pictures, whisper. But the real turning point came one spring morning when I found my back gate's lock cut, tire tracks in the dirt, and fresh trail markers hammered into my trees. "That'll wake you up." I tore every marker down and called in a welding crew. We installed a reinforced steel gate anchored in concrete. I also invested in security cameras. Best $100 I ever spent. And just a few nights later, the footage showed Karen herself creeping onto my land at 2 a.m., bolt cutters in hand, 2 HOA cronies tagging along. They were putting up new markers like they owned the place. Watching that video, I was equal parts furious and begrudgingly impressed by her audacity. I sent a cease and desist through my lawyer, assuming that'd be the end of it. It wasn't. That Friday I got served. Karen and the HOA were suing me for obstruction, for interfering with some imaginary easement, even for creating a public nuisance. They wanted $50,000 in damages and my gate taken down. I read through the complaint twice, not sure whether to laugh or be insulted. She claimed historical use, implied easements, even said my land used to belong to Willowbrook. It was pure fiction, but dangerous fiction if left unchallenged. So I hit back, filed a countersuit for trespassing, harassment, and defamation. Which brings us back to that Tuesday morning, court in session, Karen gritting her teeth while I stood calmly at the defense table. Because the thing about bullies in power suits, they never expect the quiet guy to know the law better than they do. Felt more like a circus than a courtroom. Karen swept in flanked by her attorney, 2 HOA board members, and a woman scribbling so fast you'd think the newsletter was breaking news. She even had the audacity to wear a president's pin. Like that carried any weight in a legal setting. Judge Morrison, sharp and no-nonsense, gave me a brief nod. I got the sense she'd seen her share of HOA theatrics. Karen's lawyer, a slick-talking guy named Bradley Cooper, jumped into his routine with flair. He painted me as a cranky loner, supposedly barricading the community from green spaces and walking trails. He waved his hands like he was auditioning for a courtroom drama, rambling about the greater good and how Karen's only goal was to help her neighbors. I didn't interrupt. Let him have his moment. Then I stepped forward with the facts. A deed from 1952. A land survey dated 2021. Sworn statements from 3 different generations of owners, all confirming there had never been an easement, no HOA rights, and absolutely zero public access. I even brought the receipts. Security footage of Karen and her crew sneaking onto my property after midnight with bolt cutters and tools in hand. Then came the real kicker. A stack of complaint letters signed by Karen herself, and the crown jewel, an audio clip of her telling her board members, "I don't care if he owns it. We'll make his life hell until he gives in." The courtroom went quiet. Karen's face twisted like she'd just bitten into something bitter. She stammered, trying to spin some noble narrative about the community's needs. But Judge Morrison wasn't buying it. The judge looked straight at Bradley and asked, "Do you have any documentation to back up your client's claims?" He flipped through his binder, muttering something about ongoing research. The judge shook her head. "So that's a no." Then she turned to me. "Do you wish to pursue your counterclaims?" I nodded. "Yes, Your Honor. Damages, legal fees, and a permanent restraining order." That's when Karen lost it. She stood up, voice cracking, and cried, "You can't do this. I'm the HOA president." Judge Morrison slammed her gavel and told her to sit down or be held in contempt. I couldn't help but smile. Over the next 20 minutes, the judge dismantled Karen's case point by point. Every one of her claims, dismissed. My counterclaims, approved. Karen was ordered to pay $15,000 in damages, $5,000 in legal fees, and was slapped with a permanent restraining order. But that wasn't all. Judge Morrison referred her for possible criminal trespass charges and gave Bradley Cooper a stern warning about the state bar's ethical guidelines. When we left the courtroom, Karen was swarmed by her own board members. Faces red, voices hushed, and none too pleased. Even Bradley avoided eye contact as he slipped out the back like he couldn't disappear fast enough. A few days later, I received a certified letter. Karen had been removed from the HOA board, permanently banned unanimously. The criminal charges stuck. She pled guilty, got a year of probation, and was sentenced to 500 hours of community service, far from anything HOA related. 2 months later, I was invited to speak at the state law school's continuing education seminar. My topic? When Karen Attacks, a case study in HOA overreach. That lecture went viral. My story became a cautionary tale shared in law classes and HOA meetings across the state. The HOA even sent me an apology letter and a fruit basket. The new board made it clear they wanted nothing to do with Karen's disaster. And the money I received from the lawsuit, I donated it all to a legal aid group that helps regular people push back against HOA abuse. They named their new conference room the Whitfield Warning Room. Last I heard, Karen was working reception in another state, her power grab days behind her. No more clipboards, no more board meetings, just a headset and a desk. So what would you have done? Would you have fought back or just let it slide? Ever gone toe-to-toe with a petty HOA or stood firm when the odds were stacked against you? Drop your stories below because the truth is, justice looks different in every zip code. And what counts as fair in one block might spark a scandal in the next. If this hit home, hit like, send it to a friend, and let's keep the conversation going about what's right, what's wrong, and where that line really is.